That being said, let's get into today's top story.
This scheme is irrational under any standard. Both the statute does not regulate how much any of these entities have to produce. They can produce one plant, they can produce a million plants. So the whole cap and the whole system of doling out these licenses has no rational relationship to the regulatory scheme of making marijuana both safe and available. In fact, it's keeping it from being available.
Today's top story again comes out of Tallahassee, where the Florida Supreme Court heard a second round of oral arguments regarding the Florigrown case. Now, in this episode, we're not going to dive into the nitty gritty of the case, but to give you a 40,000 degree overview of really what's going on in this case. We're in year 3 of litigation, and essentially what's happening is a MMTC applicant, Florigrown, is challenging Florida's vertically integrated medical marijuana licensing structure. Vertical integration means in order to participate in Florida's medical marijuana market, you must, as a license holder, cultivate, process, and distribute the plant. You have to grow the plant, process it, distribute the plant's products to your dispensaries, essentially seed to sale. In Florida, there are no individual licenses for the different aspects of the industry. That would be a horizontally integrated model, which I think, depending on the outcome of this case, could be Florida's fate eventually. In Florida, there are 22 total licenses available. These 22 licenses operate over 200 dispensaries and serve over 430,000 patients. So Florigrown was an applicant for a license who is challenging the state statute that enacted the vertical integration model that we have today. They're also arguing the way the legislator implemented the law turned it into a special law, which are unconstitutional. Now, on the flip side, the state is arguing the vertical integration licensing structure is constitutional, essentially that it's legal and what the state legislator did was okay, and that the state statute is not a special law, which we will break down later in this segment. So, in May of this year, 2020, the Florida Supreme Court heard initial oral arguments, which we have direct audio from the courtroom in our last episode. So, if you want to take a listen to hear the lawyers argue both sides in the first round, we do have that audio. So, definitely take a listen to that if you are interested. Back in May, I said we probably would not have an opinion by the court for months, which is typical for a state Supreme Court case. But in a unique turn of events, the day after oral arguments in May, the Supreme Court ordered the parties to write supplemental briefs. Specifically, the court issued an order directing the parties to file briefs that address in more detail Florigrown's argument that the state statute is an unconstitutional special law. So, after the parties filed their supplemental briefs, the Florida Supreme Court, in an even more surprising move, scheduled a second round of oral arguments. This one specifically to address the special law issue, which was to be held on October 7th, 2020. Now, again, this is all on the court's own motion, sua sponte, they're acting on their own. Now, the question is whether Florigrown has a substantial likelihood of success on the merits of their challenge to the statute as a special law granting a privilege to a private corporation. Now, in this case, many private corporations. Now, transitioning from the procedural history into the actual substance of the second round of oral arguments that happened in October, we have this one question presented before the parties. Does Florigrown have a substantial likelihood of success to their challenge of the state statute as a special law? Now, breaking this down into English, what is the meaning of a special law? So, generally, a special law is a law that applies to a particular place or maybe to a particular person or a class of people, or in this case, a group of private corporations that is unconstitutional if the government, here the state of Florida, the Department of Health, makes a classification in an arbitrary way or without a reasonable or legitimate justification or basis. Here, granting licenses to a few private corporations without a reasonable basis for granting those licenses. So here, the classification that's before the court is issuing of the licenses. Florigrown is challenging the application and the issuance process the state imposed in issuing the MMTC licenses. So let's start with the state's argument. So here the state is going to argue that Florigrown does not have a substantial likelihood of success on the merits because, well, there's a few reasons. Number one, all MMTC licensees, regardless if your license was granted in 2014, 2016, or 2017, they all must meet the same regulatory requirements. Now, it's important for you to know the history of how the licenses were given out, so please go back and listen to our last episode to get the finer details. But as a general timeline, the state issued licenses in different groups in different years under different schemes. So 22 vertically integrated licenses have been issued and another 11 are available. This is the state's second argument, so Florigrown, they're saying, could just apply for one of those remaining 11. And their last argument, that Florigrown does not have a substantial likelihood of success on the merits, is that if Florigrown did meet the requirements and was prepared to participate in the vertically integrated market, then it could simply just apply for one. So we have Joe Jaco. He was the lawyer representing the Department of Health in the oral arguments, and he broke down his position into essentially two pillars. First, he argued that there shall be no special law granting a privilege to a private corporation, and that the Department of Health did issue reasonable regulations, that is, in implementing their vertically integrated model, to ensure the availability and safe use of medical marijuana, which is the only task imposed on the legislator. So he's saying the legislator enacted their law included the vertically integrated system, and that the vertically integrated system is constitutional. So both of those questions are met. Second, he said the legislator tied the timing of the licensing scheme to ensure medical marijuana was available quickly and safely to Florida's population. All medical marijuana licensees get the same license regardless of when you get it. He had one quote one phrase that I thought was powerful. He said, all the licenses came from one bucket. Each license must meet the same statutory requirements. Joe Jaco also said that Section 8A is a general law, not particularized to a particular entity on its face. He's making a textual argument that the text itself does not specifically grant a privilege to private corporations. But Florigrown will argue that it was the way the legislator implemented the law that granted a special privilege to a few corporations. So here, take a listen to what Mr. Jaco had to say in October.
We've got a really strong argument on this issue about viewing it all as one bucket and not slicing it up into the different things for purposes of class. But I've had a hard time understanding from our case law how when we've talked about classifications on the one hand, and then things that pursue a kind of overarching state interest not being special laws on the other. If this had been a situation where the need for the state, the availability and safety that's referenced in the new constitutional provision, if that could have been satisfied just by expanding the licenses of the existing DOs at the time that the amendment, became part of the Constitution, would it have not been a special law if the legislature had said, okay, the people put this into our Constitution, we need a safe and readily available supply, and so we're going to expand the authority under the licenses that have already been granted, and they just left it at that. Obviously, then that could raise questions as to whether that complied with the new amendment in terms of whether that was, would it allow for sufficient, product and everything. But in terms of a special or general law analysis, would you be able to point to the larger kind of public interest as a way of saying that's not a special law, even though it's identifying, 7 known private entities and giving them this expanded authority?
Sure, and if I understand your question correctly, Justice Muniz, you're saying if the statute only had a subparagraph 1.
Right, which it seems like your argument about the public interest in the larger sort of scheme, it seems like if that's kind of an independent way to deal with the general law problem, then it almost doesn't really matter what the classification is. You know what I'm saying?
Sure.
But I don't know if that's the right way to look at the law, and I'm just curious what your view on that is.
Yeah, I have two answers to that. First, quick answer in terms of looking at subparagraph 1 and whether it's an open class. I think that it can be argued to be an open class because those licenses don't have to reside with the same MMTC that gets it initially. Those licenses can be sold, they can be transferred. That's done with Department of Health approval. So unlike some of the case law that's found a special law that benefits one city or one track, here you have licenses that can migrate to different MMTCs. I mean, even
but in terms of the privilege granted to a private corporation, the corporation that initially held that license would transfer it for a large sum of money. So they would get a privilege under the statute, irrespective of whether it could be transferred, correct?
We don't know that, Justice Lawson. One, this is a free market operation, and it's one that's done under the regulatory structure of the Department of Health. So the Department of Health has to be involved every time when those licenses are sold, as well as revoking those licenses, having those licenses surrendered. So those licenses...
The record does reflect that they are sold, correct?
Absolutely, they're sold,
Yeah.
which I think proves the point that that this isn't a closed class. Even if you look at subparagraph 1, those licenses migrate to other entities, and Florigrown itself can pursue it.
The privilege issue is irrelevant until you have established that it's a special law to begin with. And so
That's right.
It seems like the question with this public interest thing, what I'm wondering is that essentially kind of a separate way of looking at it where, if the classification is made in the interest of certain, in this case, you've got this brand new constitutional amendment. The people have prioritized this. They've given the department the criteria and whatever. And if the legislature and the department make the judgment that the best way of satisfying this public need is by essentially just expanding the authority of the 6 or 7, DOs that they inherited, is that essentially a general law, even if it only applied to that finite group of entities?
The answer is yes, and we've seen that in this court's case law.
Now, part of the state's argument that the state properly implemented this vertical licensing structure and issued licenses at different dates was that it served the public interest to make available safe marijuana. It's an issue of state importance. So the entire regulatory scheme is constitutional because essentially what he's arguing is that the statute balances the interests of the people because by timing the entry of medical marijuana treatment centers into the Florida medical marijuana market and recognizing that this plant is still illegal under federal law, the state balanced the interests, and that was the way they thought was best to achieve the goal of making medical marijuana available and safe to the Florida citizens. Justice Muniz, right in that little back and forth, thought the state's argument about of all the licenses being in one bucket was solid. He thought it was very strong. I thought he asked a great question when he said if the need for safety could have been satisfied by expanding the licenses at the time it became part of the Constitution, wouldn't it not have been a special law had they just expanded their authority? This obviously would raise questions about making sufficient product available to the population. And Joe Jaquat said, yes, because it is an open class under subparagraph 1. The licenses do not have to reside with the applicant itself. So if this was a closed class, then it would be considered a special law, thus granting privilege to private corporations, essentially the first round of applicants, which is unconstitutional. But the lawyers for the state are arguing because the licenses are transferable, which we've seen many examples of the licenses being sold, it's an open class. Anyone could get one as long as you, I guess, have the capital, which in some cases is $40 million. So Chief Justice Candidate had a great question when he asked, why do companies who are involved in litigation with the state, why do they get a head start over new applicants, over the newcomers? Because remember, some of these licenses were awarded out of litigation. The applicants did not receive a license in the first time they were reviewed. They sued the state of Florida, and they won, thus getting a license. So Chief Justice Kennedy is asking, why are these people who are involved with litigation getting preferential treatment over a new applicant? Listen to Joe Jaquat's response.
Let me ask you why it's not arbitrary to have a provision that provides that someone's eligible for a license because they brought a lawsuit. And they have a lawsuit pending.
Sure. Chief Justice, those entities were all ones that had already been evaluated and scored by the department and deemed at least close to receiving a license. So they are ones that the legislature knew the department was comfortable with, that the department believed would be up and running quickly and safely. And to be honest, even among those in 2A, there are questions of how many of those were available. I mean, there's been arguments in litigation that there were 6, some say 7, some say 10. There's not necessarily a known amount of those. It depended on the readiness of those entities that then filed the litigation. That's the basis of it. Not just the fact that they have a lawsuit, but the fact that they have a lawsuit based on the fact that they've already been scored, they've already been ranked, the department already has a comfort level and experience with them.
So Chief Justice Kennedy responds and says, so the state scored these applications, found the applicants unqualified, they did not meet the standard they needed to meet to receive a license. So now what? Why are these applicants who were deemed unqualified still in contention for licenses? Listen to Mr. Jaquat's response.
Well, no, I think I don't know how you say they've got a comfort level because they were scored and ranked and found lacking.
That may be true for the first tranche, but as the bucket grows, as more licenses come on board, the department can work with entities, can expand the regulatory scheme. It's starting with those that it has confidence with, has trust in, that have been doing this for several years, and then it expands that scope to newcomers, right?
But how would that? But how would they?
I'm sorry. Go ahead. Go ahead.
Sorry.
Yeah.
You're saying how would that apply to the second subsection? Because you're saying I understand how it might apply to the first subsection of approved, but how does that apply to the people that didn't meet the department standard? Why do they get a priority over those newcomers? And how would that not be a closed or preferential class when they clearly couldn't meet the standards of the department before, and yet the legislature is giving them an advantage over someone that's new to the industry?
Justice Grosshand, 2 answers to that. One, if there's any claimed advantage that Florigrown makes here, it's purely competition. It's that someone got a head start ahead of them, which has not been deemed to be a basis of a special law. The reason why the statute allocates in those subparagraphs is because we obviously know the DOs are ready to go. I don't think anyone can contest that. We look at subparagraph 2, the statute says these are entities that have been reviewed, evaluated, scored, ranked. They've gone through a Department of Health process. The Department of Health has reviewed them. Now, they may say they're second tier compared to those that were in subparagraph 1, but they still have been scored and ranked, right? They still have met some criteria to become an MMTC. Those guys are more ready, and not only ready, but safe to enter this market than newcomers, than those the department has no idea, including those that won't even agree to a vertical integration model, which is the case with Florigrown.
So Justice Jamie Grosshands, in my opinion, posed an intriguing question when she asked why are the companies who are in litigation with the state, who have a history as applicants and failed to get licenses, why are they being given preferential treatment over newcomer applicants? Especially when the first people, the first group, they didn't meet the qualifications. Essentially, she's saying, shouldn't the state move on and consider new applications? And I think the reason why the justices are bringing this up is because a group of applicants who did not receive licenses did sue the state, did participate in litigation, and were awarded licenses out of that litigation. I think she wants Joe Jaquat to to justify essentially why this happened to these specific applicants. And I thought it was Mr. Jaquat's cheeky response that why would the Department of Health grant a license to an entity that doesn't even agree with the vertical integration model, which is a Florigrown right here, because Florigrown is arguing that the vertical integration model itself is unconstitutional. So why would the state grant a license to a entity who doesn't even agree with how the program is implemented? But again, more on that on our last episode. So now turning the tables to Florigrown, here's what they argued. Well, first they had Catherine Giddings as their attorney. She works for a prominent law firm here in Florida, and this is essentially what they are arguing. Number one, licenses were issued to a privileged group, a long-time tree nurseries. Many of these privileged group sold their licenses. Again, others won their licenses through litigation. Second, the state has not accepted any additional applications, nor is there even an application process in place since 2017. And last, many of the 22 licenses aren't even operating, and the market is only dominated by a few. As we know, if you're a participant, if you're a consumer in the market, or you know a little bit about Florida's medical marijuana market, we know TrueLeave, one of the early MMTCs, they control almost near 50% of the market. So, she makes a good point. You've issued these licenses, and only a handful of them control the market. Take a listen.
22 of those entities have received a license. No one else has received a license. They say there are 11 licenses available. They've said there's 7 licenses available. The department has never accepted an application from anyone but these 22 entities. And what they've done is they've given them under 1, they've given them under 2, and then they've gone back down, and as licenses have become available, the department's position is that they have to meet the categories of 1 and 2, and those have to be exhausted first to the exclusion of all others. So this is definitely a closed class, because no one can ever receive the same privileges that these have had. And, they might have an argument as to one that they could be, quote, grandfathered in if they had actually been up and operating. But you've got, of these 22, he says that they're ready. The record shows that they're not. Go to the department's website. They're not ready. They're not, many of them are not dispensing. What kind of privileges are they getting that a normal applicant would not have? Well, they were just entitled to these licenses that were reserved for them. They don't have to go through a separate application process for this new type of program. They're not subject to it.
I'm sorry to interrupt you. I mean, it does, as your counsel on the other side pointed out, I mean, every single one of these buckets has the qualifier that they have to meet the requirements of this section. So
Your
it's
Honor,
it's all of the new requirements that obviously this gives them a priority in line. But it's not like they're exempted from the requirements that the legislature has decided that these entities, once everybody's up and running, has to be able to do.
No, Your Honor, they received a special privilege because they were all given a license. And of the seven in number 1, almost every one of them have turned around and sold those licenses. So they got these licenses. There were a limited number of licenses, and they sold them. I find it interesting that opposing counsel started out his argument stating that it was a regulatory function because
Justice Coriel has a question for
you. Oh, I'm sorry.
No, it's the way this works. What of the point, though, that because there is a liquidity to these things, the fact that they're transferable, doesn't that speak quite directly to the openness or closeness of the class? I mean, if it can be resold, aren't we to understand then that basically anybody can come to acquire it? Doesn't that vitiate the argument that that original group is somehow privileged, if indeed it doesn't even contain the same set of players that it used to because of the liquidity of the license?
So here, Justice Coriel asks an important question that because the licenses themselves can be sold, which again, as I mentioned, we've seen throughout the years, some licenses being sold for 40, 60 million, in addition to real property and other parts of the company, doesn't that make the class open and that the private corporations aren't receiving a privilege because anyone can require a license? Here's what Ms. Giddings had to say in response.
Your Honors, that goes to show just how arbitrary the whole scheme is, because they state that these 22 can get their licenses because they're more ready, but then they're going out and selling them. So that eviscerates their argument that this is somehow some type of permissible regulatory scheme. And remember that if you look at the definition of a special law and a general law, even if you were to find that it wasn't a closed class for these entities that were entitled to their license, you have to have, a general law operates uniformly within permissible classifications. And I would suggest to you that stating that the department was more familiar with their requirements is an after-the-fact justification. At the evidentiary hearing, the department testified that the only reason for giving the licenses to these entities was because the legislature told them it had to do so. There was no, we're more familiar with them. And so whether it's a special law or a general law, these classifications are arbitrary. They were disqualified. They were just suing the legislature.
So, throughout the oral arguments and after reviewing the parties' briefs, the state is arguing that because of the rigorous scrutiny required for a facial challenge to a state statute, Florigrown is saying on its face the statute, the text itself, not only the way the statute was implemented, but the text itself being unconstitutional, Florigrown would have to show that there are no circumstances where the law would be valid. And hitting on a point I mentioned before, the state claims there's not a substantial likelihood of success on this case for Florigrown because the MMTC licensing statute itself is a general law. That is, it's uniformly applied throughout the state in the same way to everyone. And that creates a unified system and essentially a rolling expansion of growth for Florida's medical marijuana market across the state. But remember, Florigrown is arguing that a few private corporations, they did receive preferential treatment, essentially getting a head start, which in response, Mr. Jaquad said, nowhere in the case law does getting a head start deem a law a special law. Remember, special laws are unconstitutional because they're granting a privilege to a private either group of people, a class of people, or in this case, a group of companies. Now, in response to Florigrown's argument, the state argued that the court should really be focusing on whether the framework provides for licensure to remain open to new entities, including new applicants like Florigrown. But I think that's a weak argument because the department has never accepted an application from anyone besides the 22 entities. Giddings agreed and said this definitely is a closed class because no one can ever get the same privileges the initial guys got. Of these 22, again, as I mentioned, many of them are not ready. They're not even dispensing or growing plants. Second, Ms. Giddings argued that the vertical integration structure is irrational under any reading of the statute because the system we have doesn't regulate how many plants an MMTC license holder has to produce. So the whole cap on licensing and the limitation of the vertically integrated market has no rational relationship to making marijuana both safe and available, which remember is a task imposed on Florida's Department of Health. That's what the statute says. You must make marijuana safe and available. And as a result, the legislator took that and implemented in what their opinion thought was achieving the goal of this, a vertical integrated structure. In fact, Ms. Giddings said, the vertical integration structure itself is doing the opposite. This limited application is doing the opposite because it's keeping medical cannabis from being widely available to the population. Do you think essentially that the state, in implementing this limited rollout of licenses, is achieving its goal of making medical marijuana safe and available? It's all about balancing the state interests. But later on in the oral arguments, the parties focused on the group of applicants who were deemed unqualified, meaning that they didn't score high enough on the application itself to warrant earning a license. Ms. Giddings said that these applicants, so this was the group of applicants who were deemed unqualified, they sued the state, they went into litigation, and they received a license. So Ms. Giddings is saying, how can this process be rational? Why is the department issuing licenses to applicants who failed the application process itself? One of the justices brought clarity to this issue when they when they stated that they kind of cleared up what the word unqualified means. And I agree with the justice here. What the justice was explaining that unqualified just means, you're missing maybe one or two parts of the scoring process. It's not irrational when you're defining unqualified that way. So on its face, unqualified obviously means, you're not qualified. But maybe some of these litigants, where maybe they were 95% of the way there, they were almost perfect. And at that point, the department has made so much progress with these applicants and scoring them that, let them essentially fix their one or two mishaps and then grant them a license. Some other minor points Giddings, which Florigrown has been raising since the trial level, she was essentially explaining to go and look back at the amendment. The amendment doesn't mention anything about licensing caps, no vertically integrated system, or anything like that. The regulations just demand that medical marijuana be made safe and available, and to start registering MMTCs and evaluate the qualifications. So the legislator, in imposing the cap and the vertical structure through the statute, essentially goes beyond the powers the amendment gave them. Now, to me, based on the judge's questions and the general vibes of the oral arguments, it seems like they could be agreeing with the state in that they did meet its constitutional obligations in enacting a limited licensed, vertically integrated structure. At the end of oral arguments, the court did not set a time frame for a ruling one way or another. But if the Supreme Court agrees that the vertically integrated business model is unconstitutional, our medical marijuana market is going to be open to additional standalone licensing opportunities. I mean, it's going to flip the entire market on its head. I don't know. This could have a negative impact on vertically integrated businesses because all of these businesses have established, or at least the operating ones, have established a seed-to-sale supply chain. But if we transfer to a horizontal market where individual licenses are issued based on their step in the supply chain, so for example, if you wanted to get a license just to cultivate, or you wanted to get a license just for retail, your company that is focused solely on that part of the supply chain, so for example, let's say you're a cultivator, you could drive down the price of flower by adding to the supply. Now, this will be great for the consumers, but for the current licensees, it could cause some damage to their margins. The Florida Supreme Court is expected to decide this year on whether to break up the vertically integrated structure invented in that 2017 special session. So far, the courts have agreed that the vertically integrated structure, the statute 381.986, runs counter to Amendment 2, which we know legalized medical cannabis in Florida in 2016. But even if the Florida Supreme Court rules the vertically integrated structure is unconstitutional, it will take the state months to draft rules and request new applications. But regardless, I think any ruling one way or another will provide stability to the market, so we can continue promulgating rules and making our medical marijuana market better. I'm definitely going to keep an eye out on this case because of just how monumental it is, and will report back with any developments.